Today, a federal judge ordered the Trump administration to return a long-standing exhibit of slavery to a museum in Philadelphia. Now, this is video of workers a few weeks ago removing large display panels and plaques at the President's House site. That's where Presidents George Washington and John Adams lived. The city sued, saying the government needed to consult the city before making any changes to the landmark.
Something extraordinary just happened in Philadelphia that has the Trump administration scrambling and constitutional lawyers calling it one of the most remarkable judicial confrontations of this entire presidency. A federal judge didn't just rule against Trump once, she ruled against him, watched him ignore her, and then came back harder, twice in 48 hours. And the battle she just ignited goes far beyond one exhibit in one city. This is about whether a sitting president can legally erase documented history from national monuments, whether he can crowbar out the names of real human beings from plaques at some of the most sacred ground in American democracy, and whether federal courts have the power to stop him when he tries. Make sure you're subscribed to The John Brown Show, because what I'm about to walk you through is one of the most surreal legal battles of the second Trump term. A president, a crowbar, Independence Hall, and a judge who is absolutely not backing down. Here is what just happened. Federal Judge Cynthia Roof issued an emergency compliance order against the Trump administration after they failed to follow her original ruling from just 2 days prior. Not weeks, not months, 2 days. She had already issued a scathing order demanding full restoration of a historical exhibit at one of the most significant sites in American history. The administration didn't do it, so she came back with a second order, mandatory language, bold caps, do it now. Restore the site immediately to exactly the condition it was before Trump's team took a crowbar to it. Share this video because the location here matters enormously and the media is not giving it the weight it deserves. We are not talking about some regional museum exhibit in a strip mall somewhere. We are talking about Philadelphia, the President's House site, the location where George Washington and John Adams lived as presidents of the United States, directly adjacent to the Liberty Bell. Steps away from Independence Hall, where the Declaration of Independence and the Constitution of the United States were actually written. This is not symbolic ground in the abstract. This is the literal birthplace of American democracy. And Trump sent the National Park Service there with a crowbar. Think about what was actually on that exhibit that Trump found so threatening. A tribute to 9 people, real human beings with names, with histories, with lives that were controlled, owned, and exploited by the very founders celebrated at that site. One of those 9 individuals escaped from George Washington. That is a documented historical fact, not a political opinion, not a controversial interpretation, a fact that historians have verified, recorded, and preserved for generations. And Trump ordered it removed. Make sure you're subscribed because the legal argument his administration made in court to justify this is genuinely breathtaking. When Judge Roof held her hearing, a Department of Justice attorney stood in federal court and argued that people have different opinions about slavery, that it is not the court's place to decide what the facts are on this particular issue, that the government gets to choose the message it wants to convey. Read that again slowly. A representative of the United States government argued before a federal judge that slavery is a matter of opinion on which reasonable people disagree. The judge's response was immediate and devastating. She invoked George Orwell directly in her written order. She compared Trump's approach to the Ministry of Truth from 1984. She wrote that the administration was asserting that truth is no longer self-evident, but is instead the property of the elected chief magistrate, to be distributed or erased entirely at his personal discretion. She called out the administration for claiming the power to scrape clean documented historical facts solely because the man in the Oval Office finds them uncomfortable. Share this video so people understand this is not a routine dispute over exhibit design. This is a federal judge telling the President of the United States that he does not own history. Here is the specific legal framework Judge Roof used to block Trump and why it is so significant. This exhibit and this site exist under a formal cooperative agreement between the City of Philadelphia, the Commonwealth of Pennsylvania, and the federal government. That agreement has been in place since 1950. It contains specific provisions requiring all parties to meet and confer before any changes can be made to the exhibit. Trump's administration did not meet, did not confer, did not seek any formal approval. They showed up with crowbars in January and started dismantling. That process violation alone gave the judge grounds to block the action as arbitrary and capricious under the Administrative Procedure Act. But Judge Roof didn't stop there. She went further. She laid out in plain language that the Founding Fathers' ownership of enslaved people is not disputed historical territory. It is documented fact. The names of the 9 people Washington enslaved are in the historical record. Their occupations under forced servitude are documented. The escape of one of those individuals is a verified historical event. None of this is debatable in any responsible academic or legal framework. And yet, Trump's legal team stood in court and tried to debate it anyway. Make sure you're subscribed because what Trump is doing in Philadelphia is not an isolated incident. It is part of a coordinated national strategy. This is the same administration that sent officials into the Smithsonian Institution to quietly remove exhibits. The same administration whose operatives deleted references to documented historical events from museum displays in Washington. The same executive order that instructed federal agencies to restore national sites to what the administration called uplifting public monuments while eliminating what officials described as divisive content. Divisive content. That is the phrase being used to describe the documented names of enslaved human beings on a plaque in Philadelphia. Think about the trajectory here. You start with one exhibit at one site, then the Smithsonian. Then executive orders covering all federal historic sites, then Confederate monuments being reinstated on military bases, then Army installations being renamed back to honor Confederate generals. Each individual action can be framed as a policy choice, but the pattern assembles into something that has a very clear direction. A systematic effort to reshape what version of American history exists on government property, and the courts are now the only institution actively pushing back. Share this video because what happens next in this case could determine whether any of these exhibits across the entire country stay standing. The Trump administration refused to comply with Judge Roof's first order. They then ran directly to the Third Circuit Court of Appeals in Philadelphia, seeking an emergency stay to block her ruling entirely. As of this recording, that stay had not been granted. The Third Circuit had not blocked her order, and Judge Roof issued her second compliance demand with a hard deadline attached. There is also a separate lawsuit now filed in the District of Massachusetts by conservationists and national park advocates seeking to stop Trump's broader executive order before it can be used to justify further removals at other historic sites around the country. That case is pending. Its outcome could set the legal framework for how courts treat Trump's entire history revision agenda going forward. Make sure you're subscribed because there is an additional wrinkle in the Third Circuit that raises serious questions about whether this appeal can even be heard fairly. One of the judges who could potentially be assigned to this case by random rotation is a Trump administration official who served in the Department of Justice. Legal observers are asking loudly and publicly whether that individual can impartially rule on a case where the Department of Justice he previously served is the defendant, whether a formal recusal motion is filed, or whether the assignment process produces a different panel remains to be seen. But the optics of a Trump-aligned jurist sitting in judgment on a case brought against the Trump administration to protect a slavery memorial are exactly as problematic as they sound. Think about the political calculation here because there genuinely does not appear to be one that makes any sense. Trump is expending presidential capital, legal resources, Department of Justice lawyers, and formal appellate court filings to fight for the right to keep the names of enslaved people off a plaque in Philadelphia. He is making this argument in the city where American independence was declared, before a judge who has already compared him to a dystopian authoritarian fiction. In front of cameras, during a period when he needs swing voters for the midterms. The mayor of Philadelphia has welcomed this fight publicly. She is not backing down, the judge is not backing down, the city is not backing down, and the legal agreement that has governed this site for decades explicitly prohibits exactly what Trump did without city consent. Share this video because this battle is going to escalate and every American should be watching what happens next. What is ultimately at stake here goes beyond one exhibit and one judge in one city. If Trump prevails in the Third Circuit, the precedent is set. The president can unilaterally alter federally managed historic sites, can remove documentation of events his administration finds inconvenient, can override formal legal agreements between federal and local governments whenever an executive order provides cover, can instruct his lawyers to stand in federal court and argue that slavery is a matter of opinion. If Judge Roof's orders stand, a different precedent emerges. That documented historical facts are not the property of whoever occupies the White House. That cooperative agreements between governments mean something and cannot simply be crowbarred out of existence. That the Ministry of Truth is a warning from literature, not a governing model. Judge Roof has now ordered the same thing twice in 48 hours. Restore the exhibit. Restore it now. Restore it completely. She cited George Orwell. She called out manufactured historical ambiguity for exactly what it is. She used bold capital letters in a federal court order because apparently ordinary judicial English was not getting through. 9 people were enslaved at that site by a man Americans honor as a founding father. Their names were on a plaque. Their stories were documented. One of them escaped. Those are facts, not opinions, not political positions, facts. And a federal judge in Philadelphia is making sure they stay that way. This story is not over. Stay tuned.